Oh, good afternoon, and thank you all for having me. I'm going to back up a little bit and work my way toward preemption. Traditional state tort law and the current law in most states allows a manufacturer who's alleged to have sold a defective product or a product that had an inadequate warning to use compliance with federal standards or federal regulations as non-dispositive evidence that the product was not defective or that the manufacturer acted non-negligently. In this way, traditional state tort law principles recognize that federal approval and compliance with federal regulations have a role to play, and potentially a very powerful role, in product liability cases. A typical jury instruction might say, for example, that FDA approval, though not dispositive, may be considered to show whether a product is safe or unsafe. And sometimes state law gives even greater weight to FDA approval, as in this pattern instruction from Kansas. If a product was at the time of manufacture in compliance with administrative safety standards relating to design or performance, the product is not defective by reason of design or performance unless the plaintiff proves that a reasonably prudent manufacturer could and would have taken additional precautions to design the product so as to be reasonably safe for the ordinary consumer. Over the past 20 years or so, manufacturers have argued with increasing success that regulatory approval or compliance is not only evidence to be considered on the merits of the case, but a defense to being sued in the first place. Most recently, during the past 7 years or so, the big issue is implied preemption. It's become the favorite defense of drug companies, and Wyeth is an example of that trend. But during the 1990s, the preemption cases focused on construing the scope of express preemption provisions, and Regal versus Medtronic is an example that falls into that category. The express preemption cases focus on specific statutory language that typically everyone agrees preempts, and the question is, what is the scope of that preemption, and specifically in the cases that concern us today, whether the preemption provision encompasses state law tort claims. Regal asked whether the express preemption provision in the 1976 Medical Device Amendments to the Food, Drug, and Cosmetic Act preempt claims seeking damages for injuries caused by devices that had gotten pre-market approval from the FDA. So first, a brief background about that. The Medical Device Amendments enacted in 1976. Before then, the FDA had authority to regulate drugs, but not devices. So during that, before 76, some states had stepped into the regulatory vacuum by implementing regulations of their own. For example, California had a pre-market approval requirement. Many states had requirements about hearing aids, hearing aid packaging. So when Congress was drafting the medical device laws, it had to consider what would become of these state laws after the federal law was passed and the federal program was in place. So to prevent a lot of differing requirements on the same topic, Congress enacted a preemption provision, which is codified at 21 U.S.C. 360K. And that provision preempts certain state law requirements with respect to medical devices that are different from or in addition to federal medical device requirements. In the late 80s, and much more so in the 90s, device manufacturers began to argue that this provision preempts state tort claims by patients seeking compensation for injuries caused by the devices. And the Supreme Court first considered the scope of this preemption provision and whether it applied to state law tort claims in a 1996 case called Medtronic versus Lohr. There, the court held that none of the plaintiff's damages claims for design defect, manufacturing defect, and failure to warn, the court held that none were preempted. But that product had not gone through the full pre-market approval process. It had gotten marketing permission through a more abbreviated clearance process. So the question in Regal, 12 years later, was whether the result is different when the product has gotten pre-market approval. Unfortunately for me, in an 8-to-1 decision, the Supreme Court held that damages claims arising from injuries caused by devices that had gotten pre-market approval are expressly preempted. The court held that the language of the statute, the use of the term requirements, encompasses the state law duties on which a common law claim is based. Many or most of the Supreme Court's decisions in its preemption jurisprudence begin with the notion that congressional intent is the touchstone of preemption analysis. I don't think that a single justice thought that Congress, in a consumer protection statute enacted in 1976 in a bill sponsored by Senator Edward Kennedy, had intended to wipe out a significant area of tort law. The legislative record doesn't mention the idea, but as Justice Stevens notes in his concurring opinion in Regal, by 2008, the language that Congress had used could credibly be said to apply to state law tort claims. And notably, since this line of cases began in the early 90s, Congress has not used such language without adding an additional provision to make clear that it does not intend to preempt state court or state law claims. As I said at the outset, and as the Wyeth decision that we'll hear about in a minute acknowledges, federal regulation has long played an important role in tort suits unrelated to preemption. Every state recognizes that federal regulation is evidence of non-negligence or non-defect, and in some states that evidence creates a very strong presumption in the manufacturer's favor. Such evidence presented as part of a traditional state law regulatory compliance defense gives weight to the federal approval decision, but at the same time, it allows for the consideration of the facts of a particular case. That is, in the circumstances at issue, would a reasonable manufacturer have done more? Would it have revised an approved label, for example, in light of evidence that information that it received or developed after approval? Would it have updated design approved years earlier in light of advances in technology? The problem with the Regal decision, with the holding that you cannot bring product liability claims against device manufacturers, is that it accepts FDA approval as a get-out-of-jail-free card, as opposed to evidence on the merits that a jury can consider and to which the plaintiff can respond. It applies regardless of the facts of the case, regardless of whether the company acted negligently, regardless of whether the device was demonstrably defective. Speaking of the facts of the case, I think that the facts of Regal affected the outcome on what should have been or what was a purely legal issue. A couple members of the court made clear at oral argument that they thought the Regal's claims were pretty weak. And I urge you not to let the merits of the underlying case affect your analysis of preemption issues, whether in cases about devices or drugs or foods or automobiles or other federally regulated products. The question whether a claim is preempted is distinct from the merits, from whether the defendant acted reasonably or breached a duty of care. And finding no preemption doesn't mean that the plaintiff wins. It means that the case proceeds with discovery and motion practice and potentially trial. So the preemption holding in Regal means not just that the Regals couldn't pursue a claim that some people perceived it as weak. It means as well that defendants win in future device cases as well, at least until Congress steps in, which I hope they will, including cases that people perceive as very strong. For example, based on the Regal decision, one court earlier this year dismissed hundreds of cases involving a device that the manufacturer defendant had continued to sell even after it knew that the device was defective and was causing significant injury. After Regal, a few damages claims against manufacturers of devices that got pre-market approval may still be viable. The Supreme Court stated both in Regal and in Medtronic versus Lohr, the '96 decision, that state law requirements that parallel federal requirements are not preempted. That point didn't help the plaintiff in Regal because she had waived that argument, the court said, but it could potentially provide an opening for others. So far, plaintiffs haven't had a lot of luck pursuing that argument. Courts have been asking the plaintiffs to plead the argument that the state law is parallel to federal requirements with a high degree of specificity that is extremely difficult to meet at the pleading stage, and that I don't think is consistent with what the Supreme Court was describing in Lohr and in a subsequent preemption decision called Bates, which had to do with pesticides. Another avenue possibly left open is mentioned in Justice Ginsburg's dissent. She raises the possibility that damages claims are not preempted where evidence of a manufacturer's of a medical device defect comes to light only after the product was approved, or where the device has been recalled. So Regal seems to leave open a couple avenues the plaintiffs may still pursue. I'd like to finish up quickly, I haven't been timing myself, with a few thoughts about deference. Wyeth and Regal both show the problem with allowing federal agencies any significant deference on the question, what is preempted? The briefs and regulatory statements of the FDA over the past 6 years or so make clear that the agency's preemption provision wasn't about statutory interpretation or about conflicts that impede the agency's ability to protect public health and safety. It was about a policy of tort reform. So whereas in theory, an agency's view on preemption, and in particular conflict preemption, might be important for a court to consider, in reality, the agencies weren't speaking as regulators, but as advocates. If an agency says no preemption, that would be worth considering because it's hard to believe that an agency would say that state law was not interfering with its ability to regulate if in fact the state law was interfering. But when an agency says there is preemption, I think that courts should consider that, approach that view with a high degree of skepticism. For example, in Wyeth, where the FDA said that lawsuits impede federal regulation, it didn't offer any examples of instances in which the government's ability to do its job had actually been impeded, although lawsuits and federal regulation have coexisted in the drug area for 70 years. So I think the pro-preemption position warrants a large degree of skepticism. And in Wyeth, the Supreme Court firmly agreed. The opinion speaks very harshly of the FDA's attempt to block state law damages claims. It says the FDA's view is, quote, inherently suspect, end quote, because of the manner in which it was announced, and that it deserves no deference. This is important because conflict preemption is not a choice that an agency gets to make. It occurs where, as a matter of fact, an entity cannot comply with both state law and federal law, or state law is actually interfering with the operation of federal law. Whether or not an administration favors tort reform as a policy matter should be largely irrelevant to the preemption analysis. The policy decision belongs to Congress, and as Jeff mentioned, bills to overturn Regal are currently pending in both the House and the Senate. Thank you.